the Supreme Court just agreed to hear another important Second Amendment case. This case is about state bans on concealed carry and the new rules that states created after the Supreme Court made their 6-3 decision in New York State Rifle and Pistol Association versus Bruen. Now, the Trump Department of Justice has asked the Supreme Court if they can speak during the court arguments. Also, 26 states have joined together and filed a legal document supporting the effort to remove this state concealed carry restriction. Let's talk about what is happening in this important case. Before we start this video, if you want to support the channel, one of the best ways to do that is just to subscribe. I also want to thank one of the main supporters of this channel, which is First Form. First Form is an amazing company. Their culture is unmatched. They're pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel. And also, they have amazing supplements. So, if you're trying to, do a New Year's resolution and get healthier, check them out using the links down below. And if you use those links, they have, various promotions that they have going on. So check those out. Use that link down below. And thank you again to First Form for sponsoring this video. Now, as I mentioned in the intro, in this video, we're going to be talking about the next big Second Amendment case that was accepted for review by the Supreme Court and will be argued this coming year and decided this term. This comes in a case called Woolford versus Lopez, and this is about the state of Hawaii's new laws which they passed after Bruen and the different concealed carry restrictions that they put in place. This is important not just for the state of Hawaii, but other states like New York, New Jersey, California, Maryland, and others who put in place these types of concealed carry restrictions. All of these concealed carry laws were passed in an attempt to get around or just completely ignore what the Supreme Court said about rejecting may issue concealed carry licenses and that states needed to move to shall issue. All of these state laws were passed in direct defiance to Bruen, and these laws had extremely restrictive systems where even if you got a permit, you still could not legally carry your firearm concealed because almost everywhere was off limits with their catch-all property bans. The Hawaii Woolford case asked for emergency Supreme Court help, which surprisingly was granted review by the Supreme Court. This challenge is about a temporary court order and the Ninth Circuit finding that Hawaii's catch-all public property ban is allowed under the Second Amendment. Now, recently, to the surprise of many, the DOJ and AG Bondi stepped up in support of this challenge, and they called these state bans on concealed carry a violation of the Second Amendment. That may have also helped to get Supreme Court review in this case, and kind of break the pattern of the Supreme Court where they did not take these types of emergency cases or preliminary issues. And once again, now the Trump DOJ has stepped up again in support of this case, and currently they are asking for the Supreme Court to allow them to participate during the oral arguments. Now, also a new development in this case is the fact that 26 states have filed a brief in support of striking down the concealed carry ban. Those 26 states are Montana, Idaho, Alabama, Alaska, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, Wyoming, and then also the Arizona legislature. Now, if you're not aware, this Woolford case is a challenge to Hawaii's new laws on concealed carry that they passed again in response to Bruen. This law, like others, tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property that is open to the public only if the owner of that property gives you clear permission. Plaintiffs, along with 2 organizations, sued the state of Hawaii to strike down this law, and on review by the lower court, they received a temporary court order which temporarily blocked this law. Hawaii then appealed to the Ninth Circuit, and the Ninth Circuit reviewed this case, and they also reviewed it along with the California concealed carry ban, which is very similar, and they issued a ruling upholding this catch-all property ban in the state of Hawaii. But after that, the plaintiff asked the Ninth Circuit to review this en banc, but that was denied. That then led this case to seek emergency Supreme Court help, and now the Supreme Court has granted review to this case, and they will hold oral arguments in this case on January 20th. Now, the question that the Supreme Court will answer and address in this case is whether the Ninth Circuit made a mistake in holding in direct conflict with the Second Circuit that Hawaii may automatically prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner clearly gives express permission to the handgun carrier. That means that the Supreme Court will directly address the catch-all property bans that were passed in defiance to Bruen in states like Hawaii, California, and others. Now, one of the critical things that may have led to the Supreme Court actually taking this case on an emergency basis was the prior DOJ brief when this was seeking cert petition. And once again, the Trump DOJ is jumping in support of this Second Amendment effort. They recently submitted an amicus brief arguing that the final decision of the Supreme Court in this case should be to strike down this catch-all private property ban that was put in place in Hawaii. The first thing that they argued in the brief was that Hawaii's affirmative consent rule actually violates the Second Amendment because it was designed purely to suppress concealed carry within the state. They argued that the law in question was not trying to actually follow Bruen or the Supreme Court precedent. Instead, it has the hidden agenda of simply frustrating Second Amendment rights. They argue that Hawaii already has protected property rights of owners under traditional trespass laws, and property owners could already forbid firearms from simply coming onto their property by posting signs that say something like, "No guns allowed." They also point out that the people who helped write this law in the state of Hawaii actually admitted that very few business owners would actually opt into this structure and post signs saying that concealed carry is allowed at that location. That means that this law was not intended to protect property rights, but instead to simply expand gun-free zones, which is the real purpose of this law. Now, after the Trump DOJ submitted that amicus brief, I stated that I believe that they would actually ask the Supreme Court to participate during the oral arguments that are going to happen in January. And that has now happened in a recent motion. The Trump DOJ has asked for the Supreme Court to allow them to join and participate in those arguments. So, this is great news, and it will likely be helpful to have the administration on our side during those oral arguments. It will likely also influence maybe some of the justices to rule in a pro-Second Amendment way, especially if they're kind of sitting on the fence. But also now you have 26 states who have filed an amicus brief in support of striking down this Hawaii concealed carry restriction. In this recent brief filed by the 26 states, they argue that just a few years ago, this court reminded lower courts that the right to keep and bear arms is not a second-class right subject to an entirely different body of rules than the other Bill of Rights actually guarantee. Yet courts across the country continue to defer to legislative judgments regarding firearms regulations despite Bruen's declaration that judicial deference to the legislative interest balancing is not the deference that the Second Amendment demands. Supposedly trying to address concerns about public safety and gun violence, the Hawaii legislature created a default rule against public carry on private property held open to the public. Rather than assuming that public carry was allowed unless expressly forbidden, public carry is now automatically forbidden in Hawaii unless expressly permitted. This essentially limits the right to carry to only while taking your dog out for a walk on city sidewalks. And it changes the exercise of constitutional rights into a child's game of simply "mother may I" to ensure that courts properly revert from the treatment of the Second Amendment rights as a second-class right as Bruen requires and allow citizens the full freedom secured by the Constitution. The states submit this amicus brief in support of petitioners and urge this court to reverse. So, this concealed carry case and this Second Amendment case will be huge because it's another opportunity and another case where the Supreme Court will perform the Bruen analysis looking at text, history, and tradition and look at what Hawaii did and see if this catch-all public property ban violates the Second Amendment. It will give further guidance for lower courts on how to handle Second Amendment cases and how to perform that analysis. Although, I will state that I think most anti-gun states and most anti-gun judges will still try to find a way to work around that and defy those rulings, because that's actually what they did also here with this Hawaii law. But, that's something that we want the Supreme Court to address and finally actually strike down what these lower courts are doing with their complete defiance. So, this is huge for the Second Amendment movement. This term, the Supreme Court will once again hear a critical Second Amendment case dealing with concealed carry restrictions. And the good thing is that we have the Trump DOJ on our side filing briefs in support of the pro-Second Amendment cause and also asking to participate in those oral arguments. And now you have a majority of states also jumping in support of striking down Hawaii's concealed carry restrictions. So that's what's currently happening in this critical case. As more things develop, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.